Buckle up, guys. Today we're diving headfirst into the bizarre world of sovereign citizens, where courtroom fantasy collides with hard legal reality. Right from the jump, Cornell McCrary insists on correcting the judge over how his name appears in capital letters, as if that's a legal defense. He claims he's not the Hard Caps Corporation, which tells us we're in for a ride. This isn't legal strategy, it's cosplay with paperwork. Judge Bryant hasn't even warmed up, and we're already hearing peak pseudo-legal nonsense. It's clear McCrary thinks he's found a loophole in reality itself. But spoiler alert, reality always wins. Let's just say, things are about to get uncomfortable real fast.
All right, Mr. McCrary, I'm ready.
I don't know how this stuff works. I'm new to this.
All right, this is case number 02-561-9901. The people of the state of Michigan versus Cornell McCrary. The defendant is charged with 1 count of assault or assault and battery. Today is the date set for pre-trial conference. And Mr. McCrary, your name?
Cornell Michael McCrary, ill, all lowercase, not the Hard Caps Corporation.
Alright, guys, now we're getting into the heat. McCrary starts by expressing how he feels disrespected, thinking he's about to sway the court emotionally. But Judge Bryant shuts that down fast. "I'm not interested in your feelings, sir." That's the kind of brutal honesty you only get from a judge who's been through this dance too many times. Court isn't therapy, and she isn't here to hand out tissues. She's here to move a case forward, not babysit a pro-SE meltdown. McCrary thought emotion would earn him leniency. Instead, he got a steel wall of judicial procedure. And that wall isn't budging.
So today is the date set for a pretrial conference. And Mr. McCrary, I understand that you are representing yourself. So how do you wish to proceed, sir?
First and foremost, if I may address the court and ask the court a few questions, with all due respect, may I speak?
I don't answer questions to counsel. I don't answer questions. That's not my role.
Well, I just wanted to say, when I first came onto the Zoom, I felt that this court was disrespectful and restrained my First Amendment right to allocate myself here in this courtroom. And I'm not saying this as a personal attack, but that's just how I felt.
Hey, Mr. McCrary, all due respect, I'm not interested in your feelings, sir. I'm here to conduct court. So let's conduct court. How do you wish to proceed as it relates to your court?
Now it gets tense. McCrary asks to speak without being restrained, but the judge hits him with a cold dose of reality. She tells him plainly, "Every time you go off course, you're going to be restrained. This isn't a one-man show. This is court. And whether you're wearing a suit or a tinfoil hat, you follow the rules." She reminds him he'll be treated like any other lawyer, any other defendant. That's the beauty of equal treatment. It doesn't care about your internet diploma. McCrary came to perform. Judge Bryant came to adjudicate. And she's not about to let him hijack her courtroom with off-topic nonsense.
Today is not the date for a motion. If you would like to file a motion with the court, I can give you a motion hearing date. But otherwise, I want to know, as it relates to this pretrial conference where you've indicated that you want to represent yourself, it is your responsibility to understand the rules of court and how to represent yourself. Today is only the date set for a pretrial conference. As it relates to the pretrial conference, how do you wish to proceed?
Well, if I may speak without being restrained again by the court, with all due
You're going to be restrained every time you go off course. So, understand every time you go off course, you're going to be restrained. You're going to be restrained in the same way that I would restrain any other person, any other lawyer, any other person who's not coming to court and addressing the court in the way that you're supposed to address the court for the pre-trial conference. So I'm asking you, Mr. McCrary, as it relates to the pre-trial conference, how do you wish to proceed?
I would like to ask that this court remove itself under MCR 2.003 for judicial bias.
Here comes the sovereign citizen classic, the motion to disqualify the judge. McCrary invokes Michigan Court Rule 2.003, clearly thinking he's just pulled an Uno reverse card. But Judge Bryant, Not fazed for a second. She denies it immediately and smoothly bumps it to the chief judge. This moment shows the gap between confidence and competence. McCrary thinks using legal codes makes him a legal expert. But quoting rules is easy. Understanding them is another story. His move may sound clever on Reddit, but in Judge Bryant's courtroom, it's just noise. And that noise gets shut down with surgical precision.
Well, I would like to have it sent to the chief judge as required by the rule.
Mr. Flanagan, please call the chief judge and let him know that there's a request for recusal by Mr. McCrary and ask him how does he wish to proceed with the hearing for Mr. McCrary.
Yes, Your Honor.
Violation in code of judicial conduct, Judge. And I haven't been
doing this for 16 years. I know what I'm supposed to do. So, Mr. McCrary, I'm addressing your request on the recusal. So everything else, we're going to stop talking until I hear from the chief judge as to whether he wants you to come now or if he's going to give you a date.
Okay.
Thank you.
The rule, man.
Okay, thank you, Mr. McCrary. Thank you, Mr. McCrary.
Yes, ma'am.
Your Honor.
Yes, sir.
They indicated that he would need to file a motion for recusal before you, and if you deny that, it then goes to the chief judge.
He already did. I accepted his oral motion. I denied it. So tell them it's denied. I'm not requiring him to file a written motion. The court rules don't require a written motion. He requested thank you for affirmation, but I don't need it. He requested the recusal and I denied it. So ask them how do they want to proceed. I can sign an order of denial if they want me to just do an order of denial, but I've denied the recusal request.
Yes, Your Honor, the order of denial needs to be signed.
And then they're going to give him a date. In past times, some chief judges take the matter up immediately. So I just want to know, do they want me to give them a date?
Okay. Your Honor, no date. They said just sign the order and we'll bring it up. They'll contact them for a date.
All right. So, Mr. McCrary, please contact my courtroom. Make sure that my clerk has your current contact information. And apparently the chief judge's office is going to contact you with respect to your request for recusal. I will sign an order denying your request and then forward that to the chief. Okay?
Who do my call? The clerk? What is it? No.
Sir, if you just, I promise you, I've been on the bench for 16 years, and I promise you, if you just let me talk, everything you want to know will be revealed. I promise you. Okay. So as I was saying, you're going to contact my courtroom and you will speak with the clerk. Make sure the clerk has your current contact information so that the chief judge's office can contact you with respect to your hearing on my denial of your request for recusal. Anything further with respect to this matter? Please don't unmute. Who is saying hello?
McCrary wants validation, but instead he gets a lesson. Judge Bryant, with 16 years of experience, dismantles his claims with calm authority. She affirms she doesn't need a written motion to deny his request. The court rules don't require it. It's courtroom efficiency in action. While he's playing legal charades, she's moving the process forward. This is what happens when Google University meets real-world law. She's not angry. She's not even annoyed. She's just finished with the theatrics. And that, more than anything, reveals who truly knows the game.
Well, what else is there, Mr. McCrary?
I would like to just say this, Judge. I have nothing personal with you. It's just that
Mr. McCrary, I don't take things personally. Ms. McCrary, let me say something to you. So since we're talking, let's talk. If you would let the matter proceed, this is an old case. So let me just say this case is from 2002. And maybe if you had watched my courtroom on YouTube, maybe you would have seen how these old cases from 2002 are handled. And then we could have came on here and it would have been handled the same way. However, we're going to proceed in the manner that you wish to proceed.
This is where it all comes full circle. Judge Bryant drops the mic. This case is from 2002. That's right, this has been sitting around longer than most iPhones have existed. Had McCrary taken a public defender, this could have been over in minutes. But he insisted on playing sovereign chess on a checkers board. The judge even jokes that if he'd watched her YouTube cases, he might have known better. Instead, he's stuck in a legal maze of his own making. This is the cost of thinking you're smarter than the system. Turns out, the system has patience.
Because you asked me to recuse myself, I have denied the recusal. You have requested an appeal. I have granted that appeal, and that concludes the matter. Is there anything further that is needed for the record? Because you don't have to tell me it's not personal. I could care less about, I don't take things personal. Why would I take things personal?
I take it personal because as a black man, a 50-year-old man.
This has nothing to do with you being a 50-year-old black man. This has anything to do with you being a defendant in this courtroom. Is there any legal thing for the record? Is there any legal matter for the record?
The prosecutor's office has committed a felony against me.
Okay, well, you can address that with whoever. You can address that with the appropriate parties, but I'm not. All right, so I'm going to assume that this matter, as it relates to the pretrial conference for Mr. McCrary, is concluded, unless there's something for the record on behalf of the people.
No, Judge, thank you.
All right, then, sir, you're all set. You have a great day, and you stay safe.
Here's where the train fully derails. McCrary tries to pivot the case into a personal grievance, bringing up race, age, and feelings. But Judge Bryant, she's ice cold. This has nothing to do with you being a 50-year-old black man, she snaps, reminding him this is about legal facts, not identity politics. She doesn't flinch, doesn't waver. She closes the hearing with total control. The case is now headed to the chief judge, but one thing's clear. McCrary wasted a golden chance to resolve this simply.